this case, it's very difficult, and that's why they started out with such a large jury pool. Today, they have about 50 jurors, and they're going to try to cut it down to 18. They're going to want 12 on the panel and 6 alternates. The reason they want 6 alternates is because if a juror has to leave, they want to make sure they have enough backup so there's no mistrial called for lack of a juror. This case is going to be a long, drawn-out trial. It costs lots of money to try these cases. It takes jurors' times, it takes attorneys' times, it takes the judges' time. And in this case, with so much media exposure already before the trial even begins, you have to make sure you find a jury panel that's not biased, a panel that is completely vetted and that can follow the law. So, you know, jury selection's an art, voir dire is an art, and experts are hired all the time to help in jury selection because it is arguably the most important part of a trial, because that panel, those members, are going to decide the fate and the outcome of the case. And
also because of the disturbing details of this case, right? I mean, just listening to what it's about might be like, I can't do this. I can't do this case. And let's not forget, this is a capital murder case.
Right.
So these same jurors will have to decide, if he's found guilty, whether they should sentence him to death.
Right. So during jury selection, they're going to have to be asked whether or not they have a personal belief about the death penalty. And then the attorneys have to probe further that despite any personal belief about the death penalty, can they set that aside and follow the law as instructed based on how the law is that the death penalty is an option.
That's easier said than done, though.
Well, it is, because people have their own religious beliefs, their own personal beliefs, and as much as you try to say bias and say that you can follow the law and I'm not going to bring any prejudice to the stand, that's really difficult to do because we're all complex human beings and we bring our own life experiences to the table. And then you have to shut out any thought that you've even seen this on TV or in the newspapers. That's why jurors are often sequestered in trials. Yeah. So today is phase 2. It's like this is another trial after the trial. So the first trial happened where the state had to prove its case beyond any and all reasonable doubt whether or not he was guilty. Now that he is found guilty, since he filed a motion saying not guilty he pled not guilty, and then he filed a motion to enter a plea of not guilty by reason of insanity. Now we're into phase 2 because he was found guilty on whether or not he is not guilty by reason of insanity. So this is another mini trial with the same jury. The burden now shifts. So the state had the burden to prove his guilt, but now he has the burden to prove that he is not guilty by reason of insanity, and the burden is not as high. For the trial, it was beyond any and all reasonable doubt, but for a competency trial or a mental defect trial, this one's mental defect, that's different than mental competency. The standard is clear and convincing evidence, so it's a lower standard.
Okay, so he faces anywhere upwards of almost 300 years in prison. That's the maximum sentence. Right. So what happens if he's deemed by a jury that he was not mentally responsible, that he is insane? What happens then?
Well, then he will spend his time in a mental institution rather than a prison.
But okay, I see that. How difficult is that for him to do, to try to prove that?
You know, mental illness and mental defect is the most common criminal defense to use, and it is a very hard criminal defense to win on.
I can imagine so.
You know, this case is actually really interesting, though, because since he represented himself, the jury has a real inside view onto how he thinks and possibly his own mental state. So even though a mental defect trial, the second phase of the trial, is a battle of the experts, it's the same jury. So this jury is going to bring their own experiences to their evaluation on whether or not he is insane.
Well, I have to ask you the million-dollar question, and we might be taking a break, so I might have to ask you after, is whether or not him representing himself, because anybody who's been following this case knows that for the first 3 or 4 days of this case, he was representing himself. He provided an opening statement. He even cross-examined some of the witnesses. He went through 10 attorneys, Carissa, like you said. And then the attorney, then at the 4th day, he asked for a new attorney.
Right, and so, you know, the judge determined that he was competent to stand trial. And not only was he competent to stand trial, he was competent to stand trial unrepresented with just the advice of public defenders on the sideline. So it really is now whether or not he was insane at the moment that the crime was committed, and whether or not he appreciated the difference of right and wrong at the time the crime was committed to have a not guilty defense by reason of insanity.
Right.
Well, him being not all there, it could be the case for any criminal. Any alleged criminal, anyone found guilty has a mental defect, right?
Right.
Arguably.
Of
The
course.
question is whether or not that mental defect is severe enough to qualify as a mental illness to justify a legal defense to find him not guilty.
And what do you think? I mean, we're talking. What could he argue? Because
Right.
he seemed to know what was happening. He gave well, I shouldn't say eloquent. He gave a very detailed explanation about police corruption and why, in his opening statements.
But that just means he was competent to stand in his own defense for trial. He was able to articulate now, after the fact, what's been going on. That doesn't mean that at the time the actual crimes were committed, that he had a severe mental defect that would have affected his mental state legally under the law. So that is going to come into psychiatrists evaluating him. It's going to be about all the experts. We're going to see what the psychiatrist reports say. And then the same jury that evaluated him and watched him fire 10 different public defenders and go through them like water, then has to decide whether or not the psychiatrist's evaluation is an evaluation that they find believable by clear and convincing evidence. That's the standard.
Yeah, it's more,
Clear and convincing
as we keep
evidence.
saying.
And it's his burden. It's his burden to prove that he was mentally insane at the time the crimes were committed.
Well, not to make light of a really horrible situation, but it is pretty entertaining to watch what happens.
It's also, I think, important to note, there are some allegations of him having some alcohol intoxication beforehand, and you can have a mental defect because you're intoxicated by alcohol, but that is not a legal justification under the law, because voluntary intoxication is not a defense.
Because he got drunk himself.
So I think more likely he does have a mental defect, but it's due to the alcohol intoxication, which is not a legal defense. It's not going to be because of him being mentally insane.
Well,
He had the advice of public defenders guiding him throughout the process. He was able to make a motion on his own to change his plea from not guilty to also not guilty by reason of insanity. You can't expect him to know how to lawyer like a lawyer would lawyer, but he actually, did get through most of the trial on his own. The jury's going to have a real inside view on his ability to think and have their own opinion on what his thought process may have been at the time the crimes were committed, because he did defend himself. What's interesting, though, is even though he defended himself, he didn't take the stand.
No, he did not. He did not.
So they heard from him, but they didn't really hear from him.
It's an interesting way of providing an opening statement. Is very different than being cross-examined.
Because an opening statement's not evidence.
Exactly. That's 100% true.
So whatever he said is his narrative. The jury's going to consider it, but they're not supposed to. It's a compelling argument. It goes to motive of why the police would have a motive or a reason to have Mr. Funk dead. However, I think in this case, that's a long shot. Mr. Funk wouldn't be dead if Mr. Flatoff didn't commit the crime at that time. So under the felony murder rule, the police aren't guilty. Mr. Flatoff is guilty because during the commission of his felony, even though he didn't intend to kill Mr. Funk, during the commission of his other felony, Mr. Funk died, even though the police are the ones that shot him. I think a conspiracy theory it's a long shot in this case, but it's a compelling argument in light of the civil lawsuit that was brought of $50 million. I also think it's very hard to say that the police intentionally shot Mr. Funk when he's running out the back door and people are screaming and yelling and shots are being fired and people falling downstairs and smoke's going off because a fire extinguisher got shot and there's smoke everywhere. I think it happened so fast it'd be very hard to believe that this was actually a conspiracy situation. However, what is, I think, a little unusual that can't be explained is, after Mr. Funk was shot, why did no medical assistance come to his immediate aid? There are stories reporting that he was laying there on the sidewalk for over an hour bleeding. They may go with PTSD. They know that alcohol is not a legal defense because voluntary intoxication is not a defense. So the defense is going to try to stay away from that. They have to just prove by the preponderance of the evidence that he had a mental illness or defect that was severe enough at the time that the acts of the crimes were committed. So in this case, I think that that's what they're going to go with, and they're going to rely on the psychiatrist's records. But in the opening statement that you just heard there, you heard them say that this is the only time that you're going to hear about his mental state. This is the only evidence that you are to consider. But it's important to remember that the jury is the same jury that heard him give an opening statement. So they already heard from him directly about his mental state, of how he thought those events happened. Right. Well, I believe he's a court-appointed psychiatrist, so he's there to give an opinion based on his assessments and based on witnesses that are interviewed and based on prior medical history that's being evaluated on whether or not there is a severe enough mental defect that could qualify as a legal defense. From what I'm hearing so far, it doesn't appear to be that. He's blaming alcohol, which, you know, legally voluntary intoxication is not a defense. The blackout, while he did say that dissociative amnesia is considered a mental disorder under psychology rules, that's not my thing, but it is considered a mental disorder. In this case, it doesn't appear that they are actually linking it to a mental disorder that would have been consequential to him committing these crimes. They did have a brain MRI, which, to recap, they found a lesion on his brain, which could contribute to blackouts. But they also said that that brain MRI was inconsequential as well. It's normal to black out when you are drinking. It's normal to black out if you have a brain lesion, and it's normal to black out when you're going through a traumatic event and your adrenaline is going. From what I'm hearing so far, none of this would qualify as a legal mental defect that was so severe that meant that at the time the crimes were committed, he didn't appreciate the difference between right and wrong and what he was doing. And also, another interesting thing that they brought up was, at the time he was interviewed by the police, he was able to recall facts of what happened. So that shows that he didn't black out. There wasn't an amnesia of the event. There might be a convenient amnesia for his defense, but it doesn't sound like there's a real legal mental defect that would qualify an NGI, which means not guilty by reason of insanity, argument here.
Yeah, again.
Yeah, it seems like they're listing every possible defense that could lead to a mental defect. They're listing out intoxication. They're listing out dissociative amnesia, antisocial personality disorder, multiple personality disorder, depression, anxiety, you name it, they're trying it, and this psychiatrist isn't buying it. He is saying after each one, during the wrap-up, that at the time, it is in his professional opinion, that at the time the crimes were committed, that he could appreciate the difference between right and wrong. And even though he may have a prior history documented of episodal moments of these diagnoses, that he has no evidence at the time the crimes were committed that they would have contributed to any mental defect at that time. Interesting to see. We can keep watching, but it seems like this witness is basing his professional opinion not only on his evaluation, but on other reports that he was given to review and based on a prior medical history. So the jury, which is the same jury that came down with the guilty verdict, is going to have to lend insight based on, weigh the evidence based on this professional's diagnosis, based on the reports that are being, read into evidence and the testimony. And then, they did hear directly from, let's not forget, they heard directly from Mr. Flatoff in opening statement since he represented himself. So they are going to have insight on what they think his mental state was at the time based on the way he presented his case. Even though opening statements are not evidence, it's going to be very hard for a jury to pretend that they never heard that. They heard it. So from what we hear right now, this not guilty by reason of insanity, in my professional legal opinion, I don't think it's a credible defense. We can continue to hear what else comes down, but just from this expert, and this is a battle of the experts, it doesn't sound like a credible defense. But you never know what a jury's going to do. I've been surprised in the past, and juries, I've been surprised. Well, it's going to be interesting to see what happens. It doesn't end here, that's for sure. The defense is going to continue. The defense is going to continue putting on their witnesses, and they're going to continue trying to prove that he's not guilty by reason of insanity. It's important to remember that it is the defense burden in this case. It is not the prosecution's burden to prove insanity now that he's already been found guilty, and that the standard is not beyond any and all reasonable doubt, is clear and convincing evidence and the preponderance of the evidence. So it is a much lower standard. So it really does depend on what the experts are going to say. But based on the testimony we've heard so far, the experts seem to be saying that at the time the crimes were committed, that he could appreciate the difference between right and wrong, and that there is no severe mental defect that would be a legal defense. But even there, you can expect that this isn't going to end, because if he doesn't win on the insanity defense, then he's going to be spending his time in prison, and you can bet that we will see appeals come down for ineffective assistance of counsel, for all sorts of issues, since he went through 10 public defenders and trying to prove his own case. So, you know, this definitely isn't the end. This is just part of the theatrics of a jury trial.